All right, so that looks to be just about everybody. So I think we'll get started. My name is Shawnee Collymore. I'm an estate planning and elder law attorney here at Cody McCarthy, and I've been practicing estate planning and elder law for about 14 years.
I'm Denise McCarthy, also Cody McCarthy. Also been practicing for about 14 years in the world of estate planning, as well as estate settlement, and as we'll talk about a lot today, trust settlement as well.
Yes. Yeah, so today we're going to talk about the role of trustee. For any of you that might be named as a trustee on any of your friends or family members' estate plans, or if you just kind of want to have a better understanding of what the job entails for when you're deciding who to select in those roles for your own plans, this will give you a good idea of all of the sort of responsibilities that a trustee has. So first question, what is a trust? So if you look up the legal definition, you'll find this very hard to understand explanation. Fiduciary relationship with respect to property subjecting the person by whom the title to the property is held to equitable duties to deal with the property for the benefit of another person, which arises as a result of a manifestation of an intention to create it. Like, nobody knows what that means, right? So we'll break that down for you so you can understand what exactly a trust really is. Essentially, it's when one person gives property to another person for the benefit of a third party. So if I gave Denise $100,000 for the benefit of my mom, that's essentially a trust. It's that basic. So it's just when somebody else is managing property for the benefit of another person.
Yeah, basically, one time I heard an attorney give a really cute example about his kids, about how he said he was handing out like snacks to his older two kids, and it was goldfish, and they were like sitting in the back of a car, and the youngest one was too little to just have their goldfish handed to them. So he gave the goldfish for the youngest child to the oldest child and said, just give, as the little one wants some, just give some one at a time. And that is exactly what a trust is. It's you're creating rules and parameters around the transfer of an asset from one person to another, because there's some reason, whether it be a tax reason or a capability issue or divorce protection, asset protection, there's some reason, we'll talk about a lot of them today, why you don't want to just hand over the money, the asset, the goldfish, whatever it is, to the beneficiary, to the person that you ultimately want to benefit from it, but not have total access and control over it. That, to me, is the way I think about it.
Yeah. I like that. He's starting this kid off early as a trust.
No, right? He's a trust attorney, so it makes sense.
So there are generally 4 ingredients to a trust. You have your trust maker. Also, this might be familiar to you as a donor, grantor. Those are all the same terminology. And essentially when one person, then you have the second ingredient, which is your property, and you're transferring property to your trustee, and that's the other person that's going to manage the property. And the fourth ingredient is your beneficiary. So you're transferring the property to the trustee for the benefit of someone else, and the someone else are your beneficiaries. So those are the 4 things you need to essentially have a trust: the person, the trust maker, the property, the trustee, and the beneficiary. So during the trust administration, there's going to be, we'll go over several different scenarios. The first one will be when your trust maker is alive and healthy and totally fine. The second scenario will be when the trust maker is alive but not doing well, and when your trust maker passes away. So first scenario, the trust maker creates a trust. In this scenario, we'll say like a regular revocable trust, and they're alive, healthy, and fine. At that time, your trust maker is the trustee, and the trust maker is in control of all of the money in the trust. So if you created your own revocable trust, you would be the trust maker. You're going to be the initial trustee for yourself. And essentially, the trust just says that it's for your sole benefit while you're alive, generally speaking. And you're just doing whatever you want with the money, just like you did before you put it in the trust, because the trust is for you. You're your own trustee. You just living your best life.
Yeah, really the benefit of the trust situation is kicking in if you've become incapacitated or passed away. So the idea is while you're alive and you're the trustee and trust maker, it's entirely flexible and really just an extension of you. All the benefits come after later on.
And why you might want to create a trust, one basic reason why you might want to set up a trust like this would be maybe you just want to like avoid probate for your kids and keep things seamless. You can put your assets in a trust like that where you would be your own trustee during life. Just in case you guys were wondering why you would do that. Okay, so the second scenario, so the first scenario is kind of easy to grasp, that where things are really going to come into play is when the trust maker is alive, but then they start not doing well. Okay, and then you have to figure out like when does the trust maker stop being the trustee of the trust and managing assets. So you have to look at the trust. We'll have incapacity language, and usually says something like, you know, that the trustee is no longer able to effectively manage their property or financial affairs. So when they can no longer basically handle money or understand those kinds of things in a responsible way, that's when it would be a good time for them to no longer be the trustee. Well, who's going to make that determination? Well, you have to, again, look to the trust to determine the disability of your trustee. And there's several ways that can happen within the trust. The two basic ways is that you can either have what's called a disability panel inside your trust document, where you name certain people, usually like a spouse and your kids, that make a vote essentially to say when they feel that the trustee can no longer handle the financial affairs. So they would vote, and then the successor trustee would step in as trustee. If you don't have a disability panel, then your trust might say that you have to get a letter from a doctor, sometimes more than one doctor, that essentially just says that the person is incapacitated and no longer able to handle financial affairs. And then your successor trustee steps into play.
And this is all determined by the person that wrote the trust. So if you're the creator of the trust, you would have made these decisions with your estate planning attorney, whether you want it to be physicians or if you want it to be a private disability panel. Our firm really tends to favor the panel because we've had bad experiences with somebody being disabled, having serious cognitive issues and kind of wreaking havoc on the family finances, but still presenting in front of their primary care physician for 20 minutes, 30 minutes a year and seeming fine. So there's not always, it can be nice to pull in the physician, but to be required to have only that one person make the decision, not everybody's comfortable with that. But this is something you design with your estate planning attorney. So it's written into the terms of your trust, how it would actually get determined.
And also I like having a disability panel because it's like a little bit faster and easier of a process. Like you don't have to like wait for an appointment with your doctor and like go through all those hoops. And if you have to get two letters, then you got to find another doctor to like look at the person. I mean, that could be a couple of months before you're able to do it. Doctors, you know, sometimes don't have a lot of availability. So it just can be like inconvenient too, I find, if you're like in an emergency situation.
Yeah, I just did one a couple weeks ago, and what's nice is it's really the family that is usually on the disability panel, and those are the people that know you best, are going to spot something that's really unusual. So to me, I would describe people as the protecting you from you section of the trust. And we had one a couple weeks ago, and it was really very simple. All of a sudden, very serious cognitive decline. The people on the panel said, we need to remove her as trustee. And then we created a statement for them to sign, and then a trustee change. And then very simple process versus like you said, calling doctors.
Exactly. Yeah. And another thing to keep in mind is that if you are the trust maker and you're still starting to slowly decline, most of the time, the clients can recognize that, and a lot of times they'll just step down without having this step having to happen. It's kind of more like when something drastic happens right away and like is more like kind of can be like a sudden thing where like suddenly they're sort of incapacitated and you didn't have the opportunity while they still had capacity and that recognition that it was getting away from them to just resign. So a lot of times, so it's not like happening all the time. Okay, so then, I see somebody raise their hand. We will take questions at the end, so we'll leave, so we'll go through. So if you have any questions, you can, there's a Q&A section where you can write down any questions, and at the end, we'll go over them.
And I'll try to monitor them if I can answer them as we go along. So you can feel free to chat them in the chat box. That'd be fine too.
Yep. Okay, so then we've determined that, you know, the person's incapacitated, the disability panel voted, and now we have the successor trustee has stepped in. So you, as successor trustee, the first thing you're going to want to do is to locate all of the estate planning documents. So they might have a binder. We give clients a binder with their estate planning documents. It could be in a folder, that kind of thing. So you're going to want to find that, which is a cue for me to just make sure that in your own estate planning, when you're thinking about who you're picking to be your successor trustee, make sure they know where you keep your documents and like where they're supposed to go. Because a #1 complaint of family members and friends is like, oh my God, I was looking through Betsy's house for days. I can't find the trust. They can't find anything. And it can just be like really stressful on your loved ones when they don't know where your documents are. So just let them know where you keep them to make it easier.
Yeah, agreed. Everybody's kind of got instinctively this idea every time I sign plans where it's, okay, I got to get a safe deposit box. I'm going to have to get a big, like, don't lock up your plan. They need to access it.
Yeah.
And usually attorneys, at least we don't put social security numbers or private information like account numbers and things like that on the documents. So they really don't need to be under lock and key, but it is important, as Shawnee said, to make sure your people named in your documents do know they are named. And the question someone asked was whether they have to formally be named, and that is the case. They need to be named within these documents.
Yes.
The successor trustee is named in the trust document, which does need to be notarized and signed.
Yep. So first thing, you're gonna find the binder, you're gonna locate the living trust, and that is your set of instructions that is telling you what you can and cannot do with the trust money and who you can pay it to. So those are all of the rules with regard to the trust. That's okay. Then you're gonna want to find the durable power of attorney, healthcare proxy, living will, and any asset information you can about the trust maker, so you can have a sense of like what assets are in the trust and what you're supposed to be managing and taking care of. So that should be your first step.
And I just want to touch on one thing, if you go back to that slide, because sometimes I think people don't understand the interplay of these roles. So your trust is this entity into which you will put assets so that they bypass probate and then pass on to your children or beneficiaries or spouse the way you want them to. So that's basically a bucket, an entity that holds assets. The successor trustee is in charge of managing those assets for you when you're not able to, either you're disabled or you've passed away. The power of attorney and the healthcare proxy are also acting on your behalf, but as to assets and tasks that are necessary outside of the trust. So anything healthcare related is obviously not really asset related, because it's just you. What kind of care or treatment are you getting or not getting? Do you need to be in a facility? Your healthcare proxy is making those decisions. Sometimes in entering a facility or taking actions, a contract will need to be signed on your behalf. Well, that's not pertaining to a trust asset either. So that falls under the umbrella of the power of attorney's job. And all of these roles can be the same person. Sometimes you will build little teams where, okay, this person's really better with healthcare decisions. A lot of times the successor trustee and power of attorney are the same person, because that is dealing with assets and finances. And these people kind of collaborate, because to the extent you need to be in a facility, that's going to have to be paid. Well, now that's either getting paid by your successor trustee from accounts that were in your trust, or maybe the power of attorney is managing your retirement account, because that's one big exception that can't go into the trust. So there is collaborations. Could be a team of people. It could be all your spouse wearing all of these hats. Could be one kid wearing all these hats. That again is all part of what gets designed with your estate planning attorney in the design phase of your estate plan.
Yeah, that's good to note, because to the extent that you're not picking the same person in all these roles, you have to make sure that these people can work well together.
Right.
Because sometimes there's like a feeling of wanting to like pick one kid for everything so nobody feels left out. But if your kids don't get along, then that's not a great idea. So you gotta like, think about who's gonna work well in these situations. Okay, so then you're gonna review the terms of the trust to figure out what it says, what you're supposed to do with the money in the trust during times where the trust maker and your main beneficiary is disabled. And the trust is going to outline how you can distribute money for that, for your beneficiary's benefit. Generally, it's going to say that you can make distribution, just general, it's going to say you can make distributions of any income or principal in the trust for their health, education, maintenance, and support, which is generally like for their regular sort of care needs. It's going to cover most like sort of day-to-day expenses and things that they need. And then you're going to look at the healthcare proxy and living will, like Denise said, to ensure and communicate with that person, if it's not you, to ensure that any proper arrangements are being made for their care. If they're in the hospital, or if they're, at home getting care, or whatever their needs are, you're going to need to coordinate with that person to ensure that that's sort of being properly managed and paid for as needed. Then you need to like kind of figure out like what assets they have. So hopefully they've left you in their estate planning binder a list of assets or something as a guide to start with, so you have some idea of what could be in the trust and what you're sort of marshaling to take care of, whether it's investment accounts, if they have a financial advisor that knows all of that, that you have their contact information to be able to kind of reach out to the financial advisor and figure out like what assets, if there's properties that you've got to manage, all like that. That you're able to do that and reach out to their financial advisor, CPA, all like that, to be able to start to make sure that investments and properties are being cared for appropriately. Okay. So then once you do that, you also need to make sure that you're taking care of the beneficiary's regular day-to-day expenses, because they're probably, before they were incapacitated, taking care of all their day-to-day bills themselves. Now that's your responsibility. So if they have a mortgage, paying the mortgage, or if it's homeowners insurance on the property, the real estate taxes, heat, utilities, all those like regular day-to-day bills that everybody has. Now that is going to be your responsibility to manage and sort of take care of. So you want to make sure that you have a sense of what all those bills are. In addition to, now they might have new expenses for any healthcare needs that they might be going through at the time. So as well as those. And then if your trustee has written, sometimes they'll write a letter of instructions to you to give you some sort of sense of what their general wishes are, and to act as like a guide to you when you're thinking about what they would have wanted. Not everybody does that, but it can be like super helpful for your successor trustee just to kind of have like a general sense of what you were thinking when you set up the trust. So if they have that, refer to that to get a sense of what the trust maker's wishes might have been. And then generally, well, your main job is that you have to act in the trust maker's best interest and make decisions with regard to investing of the assets and payment of bills. That's going to be in their best interest. And you need to think about like what their health needs are, and if their health condition is going to be something that requires a lot of care for a long period of time, you need to start thinking about like how you can preserve assets and take care of that person appropriately with the assets that are in the trust. So you're going to have to get a team of people to kind of help advise you. Okay. You're also going to want to keep really good records of basically all of the money that comes into the trust, into your hands, and everything that you pay out of the trust. Essentially, that's an accounting. So every year, the trustee should do an accounting to their beneficiaries, which essentially just says that the money that came in at the beginning of their trusteeship and all the money that came in during the year and everything that was paid out. And it tells you what the ending balance is after all of those additions and subtractions, so that your beneficiary or some other representative on their behalf has the opportunity to see what you're doing with the trust money and that it's being managed appropriately. That's for your beneficiary's benefit, but also for your benefit, because then it gives the opportunity for your beneficiary to review it and object to anything or not, and then you're sort of off the hook for that time period.
Serving as a trustee while someone is disabled, so you're caring for them, I personally think is the highest risk period of time for serving as a trustee, because everybody, usually it's a kid for a parent, and everybody kind of backs off because they don't actually want to be boots on the ground, taking mom or dad to doctors and paying for stuff and sorting everything out. And the person that is willing to do it and steps up to do it, nobody bugs that person during life. But then when the parent has passed away, all of a sudden, when we're divvying up the money, it's, why did you spend this much on that? Right. So then they want to pick apart every single thing you did. And I always explain this to people when I give presentations, because I think it's really important, because the fiduciary role of a trustee is basically the highest standard of performance the law will hold you to when you're acting on behalf of somebody. They take that very, very seriously. So in addition to following all the trust rules, there's the whole uniform trust code, which requires you to have a duty of loyalty to your beneficiary and impartiality and make decisions in good faith. So there's also these kind of like moral, I feel in some ways, guidelines that are in play. And what happens, because that's such a high standard of care that you're being asked to uphold, if somebody said, so in a normal lawsuit, let's explain that first. In a normal lawsuit, say Shawnee says, Denise, I'm suing you. You did the wrong thing in whatever transaction it was. She has the burden of proving that I have done the wrong thing. She has to gather the evidence, present it to a court. This is why I think Denise did the wrong thing. And then there'll be a decision about whether I did or not. When you accuse a fiduciary, so if she accuses me, so she's my sibling, mom dies, I'm done taking care of her. She says, Denise, I think you did the wrong thing with the money. That's all she has to do. And now the burden of proof is on me. I have to prove that I did not do the wrong thing. So that's why I don't think we can overemphasize the importance of keeping good records and inventorying and accounting for what you did, because in real life, what I see people do, and they're not, I don't think, motivated from a bad place, but what they will do is they will say, you know what, last week when I picked up groceries for mom, I put it on my card by accident instead of her credit card. So when I get gas for my car today, I'm going to put that on her card. And maybe it all evens out and they were doing the right thing in their minds. But in a court of law, when reduced to paper and someone's accusing you of doing the wrong thing, that is a commingling of funds that should not have taken place, and perhaps considered a breach of your fiduciary duty in the way you were supposed to have managed the assets. So those little things, I find it's the kid was doing the right thing and really not trying to screw anybody, but they've opened themselves up to all these claims. And then it turns into this big negotiation of, well, I really wanted this asset and I'm going to sue you for X, Y, Z and pick everything apart. And then, turmoil can ensue. So the cleaner you can be, we definitely recommend getting guidance. The second you become a trustee, like hire some estate planning attorney or some attorneys that serve as trustees. They don't all. To walk you through the process. We can do the trust accounting for you. You just send us all the statements and all the transactions. Then you just can sleep at night and not have to worry about it. And nothing pops up later on. So I do think that's important. And it is, someone asked, how do you know, what if your trustee goes totally rogue on you and starts doing the wrong thing? Well, you are supposed to be reporting to your beneficiary. So your beneficiary is the beneficiary of the trust. So if it was, a kid taking over mom or dad's trust and mom or dad is alive, their accounting duty flows to mom or dad. So they're really kind of in some ways self-reporting or reporting to mom or dad's power of attorney. But then ultimately the beneficiaries of the trust, so siblings, will have an opportunity to examine that record. But certainly if somebody is a beneficiary of a trust, so say you're a child and you're the beneficiary of your parents' trust and sibling is serving as trustee, even though you're not a current beneficiary, because you're an ultimate beneficiary after your parents pass, you could bring a claim in court and say, hey, I think the trustee has completely gone rogue here and doing the wrong thing. But a lot of times, this is why it's so important to maybe have a team with balance and checks and balances, because sometimes that doesn't get caught until after the fact. So it's really a good question and important in how you design your plan.
Yeah. Yep. And then, one other thing, like what you said about commingling, is just to make sure that you're always keeping the trust funds in a trust account and totally separate from your money. I know sometimes like people will have funds and they're like, oh, I'll just put it in this account in my name, or, put it with other funds because they're thinking, oh, it's a smaller amount, or they can earmark in their minds like what's theirs and what's not. It's never a good idea to do. You should keep it like very professional and like completely separate and always in the trust, so there's no issues. If you don't want it in your name, if it's trust money also, so that there's no risk of it being taken by any creditors of your own.
Agreed.
Yep. Okay. All right. So then the next part is what happens once your poor sick trust maker has died, and the first thing you will do is you're gonna hopefully review the memorial instructions that's in the estate planning binder or elsewhere, see if they've written instructions for what you're supposed to do as far as like funeral arrangements and all like that, which can be paid from the trust assets. And so you're gonna take care of all of that stuff with the family. And then once the funeral has happened, you've paid for all that, you are going to have an initial estate settlement meeting with your attorney, like somebody like Denise or I, to go over what you do next with the estate administration process, which can be a lot of work. So I definitely recommend that you take the time and spend the money to meet with an attorney to go over that process. Okay. So that's what we're saying, is establish your team of advisors. So attorney, that's your first stop, would be to your estate attorney. And you might also need a CPA to help you with taxes, and to reach out to the family's financial advisor if you haven't before, to assist with managing assets, claiming any assets now that the trust maker has deceased, and getting valuations of things. So that's who your main team is going to be consisting of. That's going to ensure you're sort of like doing all the right things. So if you haven't already in the previous steps, you're going to again get the estate planning documents so that you can have a copy of the trust, like we said before, to determine what that's your instructions as to like what you're supposed to do. Who are your beneficiaries now that the trust maker is deceased? Who are you managing the assets for? That's going to tell you whether you're making distributions outright to the people, ultimately to your beneficiaries, or if it's going to stay in trust for certain people. So that document is going to tell you all of that. So you need to determine what all of the assets are, if there's properties, if there's insurance policies to claim into the trust. Are there any retirement accounts, 401ks, IRAs? Is another person the beneficiary, or is it the trust? You have to claim all of that. And even if the trust is not your beneficiary, you will need to determine what the valuations of all of these assets are as of the date of death. And the reason why you need to do that is so that you can figure out whether the person has to file an estate tax return and potentially pay an estate tax in the Commonwealth. So current law is that if a person passes away with over $1 million of assets, they are required to file an estate tax return. That's even if you're $1 over, you have to file. And you then end up paying a tax on the very first dollar, just not on the amount over the million. Once you're over, you pay it on the full amount. So that's how it works here. And that's how you determine whether you have to file a return. So that's why it's so important to get the valuations of assets. So if you are over the $1 million, then your next step is to work with the financial advisor that you have on your team, and to get requests from them, the date of death valuations of the retirement account, of investments, and that is a special statement. It's basically like a snapshot photograph of what everything was worth on the date the person passed away. That's basically what the Commonwealth wants to see to determine the valuation of assets. So you can work with the financial advisor to get statements, and the banks. If there's real estate, you're going to get a real estate appraisal done on any property. And those are all things that your estate attorney can assist you with. So if to the extent that you've hired an attorney, which I hope you have for this process, those are all steps that we can either do for you, request the statements for you, or the client can sometimes, if they want to save money, they can do it on their own. But this is all something that we assist our clients with to figure out what the valuations are. Another thing that's important to get the date of death valuations is to help figure out if there's going to be what the new basis is in assets like real estate. So real estate generally would get a step up in basis to the fair market value on the date the person passed away. So that's essentially just like if what you bought for the property plus like what you put into the property is going to be your basis, and that's going to help you figure out like if you have to pay capital gains when you sell the property in the future. So that's another really important reason to get date of death valuations on assets, to figure out what your like new basis is in any assets that might get stepped up.
Yeah, and I will say if you can try to hire the attorney early on in the process, that it really is better because, and this goes to the financial advisors that are online with us today too, almost like everybody gets very excited about knocking tasks off the list. Like, don't worry, I already transferred the retirement account. Don't worry, I already did this. And they come to us all excited to report what they've done so far. And we have to kind of pump the brakes because sometimes we need to look at things big picture and figure out, okay, is there an estate tax? Who's responsible for the estate tax? Usually it doesn't come out of the retirement accounts, but maybe that's the only source of cash. And we need to take a big picture look. Are there debts? Where does that get paid? Is it an even distribution? We need to take a look at a lot of things before we really give you the green light to say, yep, go ahead and do that. Not to say that it's going to go slow, just that should be the order that the things happen is, sure, contact your financial advisor and let them know what's happened, and then pull in the attorney. And then usually there's a meeting with all those people to start divvying up tasks. There's a question that just came in about how you decide the value of assets included in the gross taxable estate. And so like Shawnee said, it's really a snapshot of everything that they own. If this question is about an irrevocable trust, so there are certain trusts where the assets would not be included in the gross taxable estate. If it's a true irrevocable trust, meaning that the person that set it up retained no interest in it whatsoever, then everything is outside of the gross taxable estate that's in that trust. Alternatively, it could be like a Medicaid trust where it's an irrevocable trust, but there are some strings attached to the trust maker, and that will pull those assets into the gross taxable estate. And sometimes that's honestly intentional because you're trying to get that basis step up that Shawnee was just talking about. So it's, yes, you might have estate taxes, but you're in a better position because you avoided a lot of capital gains tax. If that's the case where the trust is included in the gross taxable estate, then you include it at the value as of the date of death, because the entire trust as of that time is included in the taxable estate.
Yep. Yep. So that's why it's also really important, like you said, to speak with the attorney in the beginning, because there's a lot of steps that you might not be aware of. And like you as a regular Joe Schmo, you're not going to be able to like read the trust, revocable, irrevocable, and like figure out whether it's includable, not includable. All like that is what you need your attorney for, to
Yeah.
kind of guide you. And the process can take up to a year, the whole process from beginning to like getting everything distributed out. So it can be a lot longer than people think. So sometimes, you know, people are in this rush till they just like, you know, they want their money, they want to know when they're getting their distribution. And I know it's a lot of pressure on you as the trustee, because the beneficiaries, they're just calling you, they want their money, and there's this pressure, but you want to just make sure you kind of do things appropriately in the beginning, so you're not kind of in trouble later on.
And one just good example of what you just said, Shawnee, is the $1 million mark, because so we talk about it kind of generally as if you're over by $1, you're subject to the estate tax. But there are other scenarios where people pass away and they're under $1 million and they do have an estate tax due. It has to do with whether they gifted large gifts during their lifetime. So that's something where, again, the attorney is going to sit with you and look at everything and say, okay, you're seeing that you're at 800,000, but don't forget mom gave her house to so-and-so 10 years ago. There are big gifts like that. It very well could require an estate tax return filing. So that's why it really is important. Even if it looks super simple, just sit with somebody and be sure that you're not missing anything.
Yep. Yep. And then that way, you know, and you can let your beneficiaries know what the timeline is, and that, you know, there's steps that you have to take. Okay. So then once you've done that, you're going to try to figure out which assets are held in the trust, which assets aren't held in the trust. If there's assets outside of your trust, like IRAs potentially, or a bank account or something, is it individually owned? Are you going to have to go through probate to gain title to the property? These types of things. So you want to determine right away. Sometimes there could be like a stray bank account that never made it into the trust, that kind of thing. And you might have to go through probate to gain access to the bank account to then be able to move it into the trust. So all of that, your attorney will help you figure all of that out when you meet with them. We look at the bank statements and account statements to figure out the titling of assets, and if there's beneficiaries on assets, to kind of figure out what all of the steps that we have to take in the process will be. Disclaimer, disclaimer is when somebody decides not to accept an inheritance that they might have received for various reasons. This could just be because like maybe the surviving spouse, I don't know, has, you know, too many assets and they just want to push it on to the next generation. It could be various reasons why you might want to do that. That's something you would just discuss with your attorney. And essentially you have 9 months to figure that out. And that's also coincidentally when the estate tax return is due, also 9 months from date of death too. So those are all sort of in line. Okay. Then you're going to want to, to the extent that the trust is named as the beneficiary on any life insurance policies or retirement accounts, you're going to want to start claiming those assets and collecting them and getting them into the trust. There can be a lot of paperwork sometimes for those things, so you want to start that sort of process. If there's any real estate that might be vacant, you're going to want to secure all of the assets and marshal them. If there's a car, jewelry in the home, you're going to need to go into the home sometimes and like go through the house and figure out, is there jewelry of value? Is there artwork? Are there antiques? Is there money? You know, people stash money throughout their house. So all of these things, hopefully your trustmaker has informed you of the value of the assets, but a lot of times they don't. So you might have to just kind of go through and look through everything in the house to make sure that anything that is really valuable is secured and removed from an empty property is what I generally recommend, not to leave any valuables in a vacant property.
And there is, just so you guys are aware, if you're serving as trustee, it's not in every estate plan, but when we do trust, we almost always do this document. There can be what's called a tangible personal property assignment, or list, I should say. So basically, it could be that the person that set up the trust put all of their personal items in the trust, so their collectibles, heirlooms, jewelry, furniture, whatever it is. And then they may have left a list that says, I want this particular kid to get this particular item, or I want this cousin to get this, whatever it is, that could be incorporated into the terms of the trust.
Yeah.
And then you are required to follow it as those written in the instruction of the trust. And then there are instances where people kind of mess that up and they don't formally leave a list. They just write like a handwritten note of, yes, I want, this to go to that person. And then it becomes more of a question of, okay, you are not getting this on top of your share, your 1/3 share, but it could be part of it. So let's talk about that. And you really have to work with your beneficiaries to try to make that happen, because the standard for what you can and can't do on that type of list is different. So again, something you could chat with your attorney about to make sure you're doing the right thing with the personal items.
Yep, and that's another reason why it's so important to read the trust, because that your instruction list, that's going to tell you regarding the personal property, exactly what you're supposed to do. If they did a memo, hopefully it's in the estate planning binder, all completed. And it's also sometimes good too, because sometimes there's like an equalization within trust. Like when you're divvying up assets, like sometimes if an asset, a personal property asset is like over a certain dollar amount, sometimes some trusts will like equalize for that. So it's really is important to kind of like go through those little detailed things. Because there can be little things in there that you miss if you don't. Then the next thing you're going to do is to go over any bills, any, like expenses of last illness, funeral expenses, all those kinds of things. If there's any debts, generally like credit cards, all like that, they're required to file a claim against the estate, and any creditors have 1 year to do so from date of death to file a claim against the estate to get recovery for any debts of the decedent. So, we generally will walk you through that. If there's credit cards, you do need, this is maybe I find the biggest hassle. If the person has a lot of credit cards, you do kind of have to call the credit card companies and like cancel all the credit cards. So I find that very tedious when I've had to do that, especially when the person has a lot of credit cards. But you do want to do that and then make sure you have all the cards and then you cut them up so that they're not continuing to be used. And that sort of just protects you in the event that the card gets stolen and it was used, that you don't have to pay that charge because you notified them of the death. And then now that the trust maker is deceased, you're going to have to get a tax ID number for the trust. While the trust maker was alive and you had a revocable trust, you just use the social security number of your trust maker. But when somebody passes away, you now have to get a special tax ID number. That's not a difficult process. We can do that for you in a few minutes. And it's no big deal, but just to know that that's another thing that you'll have to do, and provide that number to any investment accounts or that there might be to be able to continue to access the assets. Okay. And then like we talked about the accounting before, when the person was alive but not well, again, you're going to have to do an accounting from the trust. Now, sometimes the trust might say that, once we do the estate tax return and pay all the bills and all like that and everything's done, it's just going to go outright to beneficiaries, but it could also stay in trust. So you need to know what you're supposed to do regarding that. But even if it's going to be a final distribution from the trust, you want to do an accounting that tells your beneficiaries exactly what you did with the money throughout the year. And it's going to show proposed distributions on your accounting to each beneficiary of what their proposed share is. You send that to them with the beneficiary receipt for them to review the accounting, accept the accounting, and sign something in writing saying that they relieve you of any sort of liability from your service as trustee. They accept the accounting and everything that you kind of paid for.
And that's another reason why we ask for people try not to jump the gun on just, I got this out to this person, got this out to this person already. Look at me, I'm halfway there. If you don't get receipts where they're acknowledging receipt of it and waiving any of your liability in having transferred these funds to them and gotten what we call an indemnification agreement where, hey, what if there's a tax, this person we find out in 6 months had never paid their income taxes in the
Yeah.
past 10 years, and now is a liability. You don't really want to be in that position where you're having to go get money, but at least if you've got indemnification agreements where they've basically said, okay, I'm taking it, but I'm not going to spend it tomorrow because I understand that until this is fully settled, maybe something pops up. You really need to have that for yourself, because there are instances where trustees, if they're very sloppy and not doing this right, could become personally liable for mismanagement of funds. And outstanding tax payments, not something the IRS takes very lightly. So they come looking for their money.
They sure do.
Massachusetts too. So
yep,
not better here.
So that's important, and that's why it's good to get advice and help, because to do the accounting can be a lot of work, and that's something that we can prepare for you. We have accountants here that just, that do accountings all the time, and it's going to be so much easier for us to prepare a professional accounting than for you to do so on your own. So it's definitely worth the expense, and just to kind of take away the heartache from yourself. Okay. Then your next step is to figure out, you've marshaled the assets, you've claimed your life insurance policies and got it into the trust. Then you have to review your trust terms to kind of figure out what you're supposed to do next, whether that's outright distributions in trust. Now, if you have a surviving spouse, there might be tax mitigation trusts. So your trust document might create a family trust and a marital trust at the death of the first spouse, and that is done to reduce the amount of estate taxes the surviving spouse will have to pay when they die. And essentially, a simple explanation for this is that the family trust subtrust that's created is just going to be funded with whatever the Massachusetts estate tax exemption amount is at the time of death. So if it's $1 million, your family trust could be funded with $1 million. That's also called a bypass share. That's the amount of assets we can kind of take out of your estate for estate tax purposes. And anything we get into that family trust will not be taxable on the estate of the surviving spouse. So we put $1 million in the family trust now. It could grow to $3 million. When the survivor dies, it's not coming back into play for the estate tax calculation. The only thing left would be taxable would be any assets in the marital trust or in the surviving spouse's own name. So it is worthwhile to go through those formulas if there's a potentially taxable estate, to try and reduce any estate taxes in the future. So that's something you definitely would have to, I don't think you could figure out on your own. You would definitely need advice from a tax attorney like us that can help you kind of figure out what you fund where and how that sort of formula works out. So that is all part of the process that will create those trusts and fund them appropriately, and kind of figure out which assets to allocate to which buckets, to see what kind of like makes sense. And then we also go through the process of retitling the assets into the different trusts. So you have if you had the Smith, in this example, the Smith Living Trust, it's going to become the Smith Family Trust and the Smith Marital Trust. So we'll decide which assets are going to go into the marital versus the family trust. Maybe assets that we want to get another step up, like the home, maybe we put that into the marital trust. Those kinds of decisions are made, and then we have to actually title the assets into those buckets. So that way going forward, the assets in the correct name. Okay. And then one other thing on the trust, then you're just going to kind of read the trust terms to figure out how you can make distributions to the spouse from inside the family trust and marital trust, and if there's any other beneficiaries contained in the family trust, like descendants that you might be allowed to make discretionary distributions to. So that's why it's important to kind of review the trust terms with your attorney to figure out who you're allowed to make distributions to, and like what's the distribution standard. then the estate tax returns that we talked about, they're due 9 months from the date of death of the decedent. So you got to keep that sort of date in mind, and figure out if there's going to be federal estate taxes or just taxes to the Commonwealth. Currently, most people are not paying federal estate taxes right now just because the federal estate tax exemption is very high. It's like 12.9 million per person. So if you're married, you would essentially have to have more than $26 million before you paid a federal estate tax. And most people don't have more than $26 million, although lots do. So a lot of clients are just worrying about state taxes to the Commonwealth of Massachusetts. But that's all stuff that your attorney can help you kind of like guide you. And then you're going to have to also do income tax returns. So the decedent is going to have a final income tax return. If they're married, the spouse will likely do that. But then if there's trust, the trusts might have to pay, might also have income tax returns that they'll have to file. So you can work with your attorney to assist you in filing those, or your CPA can help you prepare those and pay any income taxes on the trust assets that might be required going forward. And then you're going to pay all of the final expenses. Like I said, if there was any expenses for last illness, funeral expenses, bills, there's going to be, the expenses of administering the estate, the attorney's fees, any probate court fees, if there's estate taxes, all of those type of expenses will get paid. And any creditors that appropriately filed a claim against the estate, those kinds of things have to get paid. So going through all of that and paying all the just debts and expenses and bills that have come up through the administration, preparing the final accounting, sending that to your beneficiaries to sign off on, and then making final distributions as noted in your final accounting once everybody has signed off on the accounting. So if they're getting an outright distribution, you're gonna figure out with them whether you're going to do the distributions in kind, like if you have stocks and investments, are you just retitling a portion of the investment account in their names, or are they getting cash? Those are things that you need to communicate with your beneficiary about, what their preference is, getting assets in cash or in kind. Same thing for real estate. Is the property just being sold and distributed? Is somebody buying it out, buying the other beneficiaries out? Those are all things that you just need to discuss with them. And then if there's a trust for your beneficiaries, which happens all the time, maybe a general needs trust or a special needs trust, this could be because the reason why you might want to do a general needs trust for your beneficiaries would just be for asset protection, to protect any assets from a divorce or creditors. For your kids, you might want to consider doing a general needs trust for them, or maybe they're just terrible with money and you want to protect them that way. A special needs trust would be done for a beneficiary that might be disabled, to just make sure that you preserve any public benefits they might be on. So those are all things. You also have to look at your trust to see what terms are in there of how your beneficiaries receive their share. And of course, like I said, you get the beneficiary receipt from the accounting before you've made any distributions to them directly or otherwise.
I know we're kind of coming up on time, but I think the duties we can kind of really just go through quickly, but I just want to touch on that. General needs trust share. A lot of times people have designed their estate plan so that so maybe all of the settlement work is complete. So the trustee's done with all the payment of taxes, settling everything, gathering all the assets, figuring out, okay, maybe there's 3 kids, it's going to be a third. Well, that could be the termination of the trust if the trust instructs you to just give the assets out and do what we call an outright distribution. But a lot of times it could be you have an ongoing role to manage the assets for a particular beneficiary because the person that set up the trust wanted to protect it. They didn't want the money from the trust to be included in a divorce. They didn't want it to go to creditors if the kid has credit card debt or is spendthrift. They didn't want it to be a factor in a divorce. I think I just said that. but they don't want it to be treated as the kid's money for whatever reason. And sometimes if they really want very good asset divorce protection, they're switching over to someone like us serving as the trustee of that share. So you could be handing off to another trustee. I just want to make sure that's clear. And if you have that in your trust document, just understand why that handoff might happen. It could very well be that, okay, now that each kid has their share, this one is awful with money, we need it managed by a professional, and then you'll be handing off the trust share, not all of your duties prior to that.
Yes, that's important. So when you're meeting with your estate planning attorney, whether here, to the decision of like who would be the trustee for your general needs trust for your kid is really important, depending on the level of asset protection that you want for them in the future. So that's definitely a conversation you should have with your attorney. Okay, and then the trustee duties. So it's a lot of the things we've sort of touched on, but generally to manage the trust property for the benefit of the beneficiaries, that's your main duty, is to use and manage the trust money for the beneficiaries. You're going to follow the trust instructions that tells you how the beneficiaries receive their distribution and how you can make distributions to them. Which is generally, and that helps you carry out the trust maker's wishes. If there's any third, like outside writing, besides the trust, you can refer to that. Sometimes trust makers will leave you a little letter that's not binding, just to help show what their intention was, and that can help you with making distribution decisions.
And then in the next two slides, you really just kind of articulated some of those duties I was talking about that are found in Massachusetts trust law, which generally apply unless your trust has somehow specifically said that you don't have this duty, which most would not. You're going to have these duties layered on to your responsibilities. And they're basically some of those ones I was talking about earlier, where it's just kind of like having a good conscience and being impartial to the beneficiaries, not favoring one over the other as you make decisions. Because sometimes you're making decisions about, are we selling this property, are we keeping this property, are we liquidating this business, who's going to be in charge of this business? You have a duty to all your beneficiaries. Essentially equally. And so we've listed a lot of these, but we have gone through a lot of them, like the duty to render the accounts, duty to keep property separate. So once you've got, everything split up, who's getting what, now you're keeping that all separate. You have the duty to take possession and control of the assets right out of the gate and make sure you know what you're in charge of. You have a duty to invest prudently. So if it's going to take a year, like Shawnee said, I'm sure like COVID, post-COVID, I feel like is even more of a rocky road example of how 1 year can make a huge difference. How are you going to protect yourself from lawsuits against the beneficiary saying you didn't manage the money properly, and now there's a huge loss. And if you distributed this 3 months ago, I would have had X, and now I have Y. I helped beneficiaries get more money out of a trust because their trustee took 7 years to make a distribution, and basically cost them a ton of money, because by the time he was ready to distribute the real estate, it had like almost doubled in value. So they didn't get cash that should have, or investments that would have also increased. So that's kind of an extreme example. I'm not seeing people take that long, but in a year or 2 years, if you are not on top of these things, you're opening yourself up to liability. And then if you go to the last slide, is just where we've outlined what the repercussions are. If you have failed in your duties, they can go to court for all of these actions, they being the beneficiaries. So if the beneficiaries feel like you've breached, they can go to the court and either request an accounting, force you to take some action, remove you as trustee, ask the court to deny trustee compensation so that you can't get paid, because generally trustees can get paid for their duties. So there are certainly very serious repercussions for having failed in your duties. So I think the big takeaway, because I'm just trying to leave time for questions too, should be that people don't take the role of the trustee lightly, especially when you're dealing with family and friends, which is very often the case. People pick people in their circle to be their trustee. We can't emphasize enough how you need to just switch in your brain that, okay, I'm performing a fiduciary duty here. I need to take it seriously. I need to make Excel spreadsheets my friend and keep folders of records and really treat this in the formal sense that it should be.
Yeah, and then one quick thing on the trustee compensation. Trustees are allowed to get compensated, but generally it has to be reasonable compensation. And if you're not a professional trustee like Denise or I, for a non-professional, it's starting like $50 an hour. Around there is going to be a reasonable fee. So you need to keep track of your time when figuring out like what you're going to pay yourself. So that way, if anybody asks why you're taking $10,000 or whatever, you can say, okay, this is exactly everything I did went up to this hours. And you can show, as opposed to sometimes, people are just like, well, I think I'll just take 25,000. That seems reasonable for everything I did. And you don't have anything to sort of back up how you got to that number. So also remember to keep track of your time, even though it can be a little bit tedious. It'll be worth it if any of the beneficiaries say that you paid yourself too much. Okay, so generally what we want you to keep in mind is to remember that trust definition, your 4 important people. You have your trust maker, you have your property, you have your trustee, and you have your beneficiaries. And you want to keep that trust as your operating manual, your list of instructions that's telling you every single thing that you're supposed to do. And then when needed, make sure that you're seeking advice from an attorney, a qualified attorney that practices trust administration and estate administration that can advise you as to your duties going forward to make sure you don't make any missteps, and you will be okay if you do those things. Thank you for listening to the presentation. Hopefully it's helpful. If you have any follow-up questions, feel free to reach out to us and ask any questions. If you want a copy of any of the materials, you can email Lindsay Babineau at the address on the screen. And we will be having 2 other presentations this summer. Our next one will be June 12th at 8:30 on how to serve as a power of attorney. We did touch on how there's an interplay between serving as the trustee and a power of attorney for assets outside of the trust. And we will kind of go over next time what the job of the power of attorney is and how that's different from the trustee. And our final presentation will be June 30th. And that will be on avoiding and simplifying the probate process, and generally how you can avoid going through it, and how you can make, if you do have to go through probate, how you can make it a little bit easier. So if there are any final questions, I'll give you the opportunity now to raise your hand or post something in the Q&A box if you have questions on anything we covered throughout the presentation.
And I know we're past time, so if anyone needs to drop off, just feel free to drop off. We won't be insulted. And you can always email us, like Shawnee said, so just reach out.
That's right. You can email us, and you can email Lindsay if you need any of the materials or have follow-up questions on anything. Okay. All right.
I think we might have answered the questions all as we went along, so I think we're good.
I think so.
Thank you, everybody.
All right. Thanks for attending.